Let's understand what are the elements of partnership. That means what are the requirements of partnership. So the first element of partnership is association of two or more persons. So what do you mean by association of two or more persons? That means to call an association, there should be at least two persons. That means for a partnership, there should be at least two persons to start a firm. If there are less than 2%, that means there's only one person, that will not be constituted as partnership. It will become a sole proprietorship. So when you're talking about association of persons, there are other sub points which you need to remember. So first one, at least two persons. So what is this? Is the minimum? Is there a maximum limit for number of partners? Yes, earlier the maximum limit for a partnership was 10 and 20 in case of banking and general business respectively. But now, irrespective of the business, the maximum limit for a partnership is 50. So remember, to start a partnership, there should be at least two persons and not exceeding 50 persons. So this is the first sub point under association of persons. The second point is capacity to contract. So you all know what is capacity to contract, right? So in a contract, the persons entering into a contract should be capable of entering into contract. Now, is partnership a contract? Yes, the basic essence of partnership is by virtue of an agreement. That means all these people came together, they pooled in resources on the basis of agreement between these people, right? When these people are coming together to form a business, they should be capable of entering into contract. So who are people not capable of entering into contract? One is minor, second is unsound mind, next disqualified by law. Right? So you've already studied all these aspects. So who is a minor? A person who has not attained the age of 18 years cannot enter into an agreement. If they enter into an agreement, that will be void ab initio, right? Coming to unsound mind, when a person is not in the state of mind to make a rational judgment whether the agreement is in favor or not, or he could not understand the terms and conditions, then such agreement will be void ab initio, and also disqualified, and also persons who are disqualified by law, that is alien enemy, foreign ambassadors, insolvents, convict and corporations. So these are the 5 categories under disqualified by law. So as per Indian Partnership Act, a minor can be admitted only to the benefits of the partnership firm. That means to enjoy only the profits and not share losses. So this is one exception given for a minor. When a minor needs to be introduced in a firm, a unanimous consent would be required. So this is the third aspect. Next, free consent. So you all know what free consent is, right? That means when persons are entering into an agreement, they should be entering with their own will. They should not be forced. Free consent should not be vitiated by coercion or undue influence or fraud or mistake or misrepresentation, right? So all these elements which you studied in Indian Contract Act will also apply to Partnership Act, because the essence of partnership is an agreement. So these are the sub points you will need to remember on first point, that is association of two or more persons. Next, moving on to the other element, that is agreement. So as I said, the basic essence of partnership firm is agreement. So what exactly is this agreement? It is nothing but the terms and conditions between the partners. So what are the terms and conditions? So remember, when you had the business idea, you were in need of capital, you approached your friend. So he would be giving you certain terms and conditions saying, I will be contributing so and so capital from so and so time and I need so much share of profit. Is this a term and condition? Yes, that will be mentioned in the agreement. Second, the rights and duties. So when people are coming together to form a business, the mutual rights and duties should also be discussed. So the rights and duties of all the partners is mentioned in the agreement. So when we say all these terms and conditions or rights and duties, authorities, liabilities in a partnership agreement, it means all these terms and conditions could be either in writing or in oral. You all know when you were studying in Indian Contract Act, an agreement could be either in oral or in writing. Similarly, even partnership agreement could be either in writing or in oral. So, but it is always advisable in the long run to have these terms and conditions in writing. Why? Because to avoid future disputes in the business. So, when we say the agreement could be in writing or in oral, you also need to remember this agreement, if it is in writing, could be either registered or unregistered. So, as I said, the agreement could be either in oral or in writing. Again, the option given in Indian Partnership Act is this agreement, if it is in writing, could be either registered or unregistered. When you learn about company law, you will come across there is a compulsion for a company to be registered under Registrar of Companies. But for a partnership, it is optional. That means at the discretion of partners, they can either get their firm registered or unregistered. But always remember, an unregistered firm will have more advantages over unregistered firm. So, what are the advantages? You will be learning in the upcoming videos when you will be learning about the registration process and also the advantages of registered firm over an unregistered firm. So, these are the 4 points that you need to remember under the second element, that is the agreement. So, first of all, the agreement is nothing but the terms and conditions between the partners, which talks about the profit sharing ratio, their rights, duties, authorities and liabilities, and also how to dissolve a firm. Next, coming to these terms and conditions could be either in writing or in oral. Again, if it is in writing, it could be either registered or unregistered. So, these are the 4 points you need to remember under the second element. Moving on to the third element, carrying on some business. So, what is business? Business is nothing but some form of trade, occupation or profession. So, what was your intention? Your intention was to earn profit. How? From a business, right? So, whatever business you are coming up with, whatever business idea you are coming up with, that becomes the subject matter of this agreement. So, you all know, again coming back to Indian Contract Act. So, for a valid agreement, there should be a subject matter, that is the lawful object. So, here the third element, that is carrying on some business activity, becomes the subject matter or object, and this object should be lawful. So, these are the 3 points that you need to remember under the third element. Third element is nothing but organized to carry some form of business. What is business? It is nothing but a trade, occupation or profession. So, this becomes the subject matter of your agreement. Next, moving on to the fourth element, it is sharing of profits. Sharing of profits is basically the prima facie evidence for existence of partnership firm. When I was talking about the relevance of partnership or how partnership is formed, first of all, you started a business idea, then you asked your friend to contribute capital. He was ready to contribute capital only with the intention of earning profits from the business, right? If he had no intention of earning profits, he would not contribute the capital. So, sharing of profits is one of the prima facie evidence. But remember, sharing of losses is not a prima facie evidence. That means, so there are few partners who will be sharing only profits of the firm and not share the losses. So, who are those partners who will be only sharing profits? It is minor partner, as I said, and also there is one type of partner who is called as partners in profit only. So, remember, under the fourth element, that is sharing of profits, remember, sharing of profits is a prima facie evidence. If there is no sharing of profits, then we cannot say partnership is existing between two persons. You need to remember this word, prima facie. Second, only profits, not losses. So, when they are sharing profits and losses, in what ratio they would be sharing? They would be sharing the profits and losses as per agreement. That means, as agreed, or equally. That means if the profit sharing ratio is expressly stated between the partners, they would be sharing the profits as per the agreement, which could be either in writing or in oral. And if they have no specific profit sharing ratio, the profits and losses will be shared equally. So these are the 3 points which you need to remember under the fourth element. Coming to the next element, that is business must be carried on by all or any one of them acting for all. So as I said, for in a partnership firm, minimum there are 2 persons, maximum there are 50 persons, right? If there are 50 persons in a partnership firm, not necessary all the partners should take part in the management. Either 1 person or 2 persons or 3 persons, any of them who are interested in taking part in the management can take part in the management. But having said that, while taking any decision, the other partners who are not taking active part in the management have right to be consulted. So remember, for a partnership firm, 1 person can take part in the active part in the management, or all the partners can take part in the management. So when 1 person is taking active part in the management, he is acting as an agent on behalf of all the other partners and also as an agent on behalf of the firm. So when the other partners who are not taking part in the management, they will be acting in the capacity of principal. So there is mutual agency between partners, and also there is mutual agency between a partner and the firm. So the partner is not different from the firm and the firm is not different from the partnership. So these were the elements of partnership. Hey guys, welcome back to our lecture on company law. In today's topic, you'll be learning about one of the important feature of a company, that is separate legal entity. In a previous video, you've already learned the features of company, but now the separate legal entity principle you will be understanding in detail, because this is one of the distinguishing feature of a company. So what exactly is a separate legal entity? So separate legal entity means separate existence or distinct existence from its members. So who are members? So when you were learning the definition of company as given by Justice Lord Lindley, he says company is nothing but an association of persons where people come together, pool in their resources. The person who's pooling in the resources will be called as a member. When will he be called as a member? When he contributes a resource to the company, and accordingly a share will be allotted to a person. On allotment of share, the person will be called as a member, right? So he will also become the owner of the company. Now we are understanding what are the rights would be of a member and what would be the rights of a company. So remember, though the company is formed by the members and managed by directors, the company has its own existence in the eyes of law and it is distinct from the members and directors. So when will company gets this artificial existence or separate legal existence? On incorporation. So when is incorporation complete? On receipt of certificate of incorporation. So in the further videos, you'll be learning about how incorporation of a company will be done. So here, so right from the promotion stage till the receipt of certificate of incorporation from registrar of companies, the company will not come into existence. Only on receipt of certificate of incorporation from the registrar of companies, who is the authority to issue the registration to a company, only from then company gets an artificial person existence, and also it is treated as a separate legal entity. When we're talking about artificial person, I told you company will be enjoying all those benefits just like a natural person, but it does not comes under the natural process and it comes into existence by law, and its existence only in the eyes of law. It is called as artificial person. So what are the rights of a company? So the rights of a company would be, it has its own name, that is a company is identified by its own name. It has its own existence. It has all the rights to enter into any contracts in the company's name and not in the name of the company, in the name of the member or of a director, right? And once it has a contractual capacity, it has also the rights to sue and to be sued. And also all the bank accounts will be opened in the company's name, and also the people who are working in a company are employed, that is a contract of employment will be drafted in company's name and the candidate's name, right? So all these rights are with the company. So it is distinct from the rights of a member and rights of the company. So here one of the important point to remember is the members are not liable for the actions of the company and the company is not liable for the actions. Why? Because there is some distinguishing feature between a member and the company. So this principle of separate legal entity is explained well in one case law which is called as Salomon and Company Limited. So let's see what happened in this case. So there was one person called as Arnon Salomon. So this person was a sole trader. So what is sole trader? So any person who is taking a form of organization, that is a sole proprietor form of organization. So what is a sole proprietor organization? Which means a form of business organization where there is only one person who contributes to the capital and also takes part in the management. So there is no division of control, there is no division of profits and loss, and also there is unlimited liability. So this kind of business, what was the subject matter of this business? He was basically a leather trader, that is he was into leather manufacturing and boot manufacturing. So this was the first stage of this case. So second, over a period of time, the same person, that is Arnon Salomon, he started another company. So here remember there are two forms of organization, one is sole proprietorship and one is company. So this company which he formed was also into the same kind of business. So what was the kind of business? Leather and boot manufacturing business, just like what he was doing in the sole proprietorship form. So now you know the difference between a sole proprietor and a company, right? So in company there are two or more people who pull in their resources and there is separation of ownership and management, and also company has a separate legal entity and also it is treated as an artificial person, but whereas sole proprietorship, it does not enjoy any of these benefits. So this was the first stage in the case. So the company which he formed was named as Salomon and Company Limited. So it was named by his name, that is Salomon and Company Limited. So now while I was explaining the differences between company and Hindu undivided family, I told you there are three categories and also there are other categories, but most importantly one of the important kind of company was public limited company. So how do we identify if a company is a public limited or a private limited? For a public limited company, the name of a company would end with limited. Okay, so that means the liability of the members is limited. In case of a private limited, it would end with private limited. So now this Salomon and Company Limited, how is the name ending? It is ending with limited, right? That means this is a public limited company. So in this, let's understand who were the members, who were the directors and who were the creditors. So for forming a public limited company, how many members are required or how many people should be subscribing to the Memorandum of Association? It should be 7, right? So here the first member was Salomon himself, that was the sole proprietor who had his business, then he formed a company and the company was named by him. Second, his wife was a shareholder, that means even she had contributed to the capital. Third, his daughter and 4 sons. So all put together will make 7 subscribers. 4 sons, daughter, wife, Salomon himself. So 7 subscribers were done. Next, coming to directors. So you all know the management is separate from the ownership, right? So who were the directors? Who were the persons responsible for managing the business? It was nothing but Salomon himself and his 2 sons. Now you would be thinking, I have already told you that management is separate from the ownership. Does it mean that one person cannot be acting as a member and cannot be acting as a director? No. What I said was, when a person has to manage the business of a company, they need to be elected by the members. So these elected representatives are called as individually directors and collectively called as board of directors. So, but that does not bar one person acting as a member and the same person acting as a director. But while taking decisions, they would be acting in their individual capacity. So this was one of the again principle in this case law which says one person can become a member and a director but should be acting in their respective capacity. Next, coming to creditors. So for a company, financial resources is very important, right? So the sources of finances would be different. One would be the savings of the persons, one would be contributions by the members themselves, right? In case these resources are not enough, they would be taking financial resource from the outsiders, that is the creditors. So when we are talking about creditors, we have classifications of secured and unsecured. So what is secured creditors? Secured creditors are those creditors who have a charge on the assets. So what do you mean by charge on assets? Which means they have an interest over the assets in case the company cannot pay back the debts of the secured creditors. The assets of the company will be utilized, that means it will be sold, and the proceeds of those assets will be utilized for settling the debts of the secured creditors. So what is unsecured creditors? It is just opposite to secured creditors, which means the unsecured creditors will not have any charge on the assets of the company. So now let's see who were the secured creditors and unsecured creditors. So secured creditors, so Salomon himself was the secured creditor. How? There was a debentures worth £10,000 issued by the company to the Salomon. So remember here, so basically debenture is nothing but a certificate acknowledging debt. So the debenture holders are called as secured creditors. And generally all the debentures will have a charge on the assets of the company. And also there were other unsecured creditors, that is those people who did not have any interest on the assets of the company or did not have charge on the assets of the company. So that was amounting to £8,000 and the secured creditors were £10,000. So this is important while we are discussing about the last stage of this case. So till now just remember, Salomon was acting in three different capacities. One as a member, second as a director, and third as the creditor. Okay. So here remember, one person can act as a shareholder also, can act as a director also, can act as a creditor also. So let's see what happened in the case further. So now remember, Salomon also had a sole proprietorship, right, which was into leather and boot manufacturing. So later he started the company. Now rather than having two business organizations which is having the same subject matter, what Salomon decided was, he decided to sell his sole proprietorship to the company. Remember, company has a separate legal existence. That means the member is different from the company. So what Salomon did was, he sold his sole proprietorship which he was owning to the company. Which company? Salomon and Company Limited. So when you're selling any business to a company, obviously there will be a sale price involved, right? So now Salomon was supposed to receive a consideration for selling his business to the company. So this consideration was split into three parts. So the total consideration was £38,782 and this £38,782 were divided into three categories. So the first category was in form of debentures, second category was in form of equity shares, the last was in cash. So how much was debentures issued? Remember, while I was talking about creditors, I told you Salomon was also a secured creditors because debentures were issued to Salomon worth £10,000, right? So debentures of £10,000 were issued as a sale consideration for selling his sole proprietorship business. Apart from debentures, equity shares of £20,000 were also issued and the remaining amount of £8,782 were paid in cash. So this was the classification of sale consideration which was paid by the company to Salomon. Okay. So this is the third stage in the case. What was the first stage? First stage was he had a sole proprietor firm, then he started another company. So in the second stage you understood who were the members, who were the directors, who were the creditors. So this is the third stage in this case. That means over a period of time, Salomon sold his sole proprietorship to the company which he formed, that is Salomon and Company Limited. Whenever a business is sold, the consideration should be given by the company to the person who is selling his business, right? So now who was selling business? Salomon himself, right? And the consideration was in total into £38,782 and this was split into three categories. One was in form of debentures, equity shares and cash. So let's see what happened in the next facts of the case. So over a period of time, company ran into difficulties. It had lot of losses. So Salomon and Company Limited was in the verge of liquidation. That means it was in the verge of winding up. So at the winding up, usually what happens is whatever the debts of the outsiders are to be repaid. So that means how much is the assets and how much is the liabilities should be checked. On the liquidation date, the assets were £6,050 and the liabilities, that is the debts, were £18,000. So as I said, to pay back the debts of the outsiders, the assets of the companies are utilized. Now remember, if you can see here, 18,000 is more and the assets for paying the 18,000 pounds is less, that is assets are only 6,050 pounds. Now coming to the liabilities, you all know when I was talking about creditors, there was secured creditors and unsecured creditors, right? So amount of 10,000 pounds were secured by debentures, right? And the remaining 8,000 was unsecured creditors. Now who was the secured creditor? The Salomon, right? Because he had debentures worth 10,000 pounds and always debentures have a charge on the assets. And the remaining unsecured debt was 8,000 pounds. So usually in liquidation, what do they do is, first the secured creditor's debt will be satisfied. That means the 6,050 pounds whatever was available in the form of assets, that should be sold and the proceeds should be utilized in satisfying the debt of secured debt. And later if anything is remaining, now in this case nothing is remaining, usually if there is anything remaining, only then unsecured debt will be paid off. So in this situation, the entire 6,050 was utilized for satisfaction of unsecured debt, and unsecured debt, the creditors did not have any mode of recovery of this money from the company. Now obviously the unsecured creditors filed a case in the court of law. Why? Because they said initially Salomon himself was the sole proprietor, he started the company and the company was formed and managed by his own family members, right? That is himself, his wife, his daughter and his 4 sons, and also the directors were Salomon and his 2 sons. So what unsecured creditors said was, the company is not different from the persons forming it, that is Salomon. He was a mere agent of the company. So the 6,050 whatever was there in the assets, that should not be utilized for paying the debts of the Salomon, that is the secured creditor, but it should be utilized for the satisfaction of unsecured debt. So this was the allegation made by unsecured creditors. So what they said was, this entire 6,050, that is the assets, should be utilized for satisfying the debts of the unsecured creditors. And also the what was the ground was, Salomon was only the agent of the company and he was not entitled to receive any payment from the company. That means the unsecured creditors claim should be first satisfied and then the secured creditors should be satisfied. And also, since Salomon is the principal beneficiary, so who is the principal beneficiary? The person who is holding the shares. Now who was holding the shares? Salomon and his family members, right? So a person, whether he is directly receiving an interest or his family directly receiving an interest, would be called as a beneficiary. So, and also he was ultimately responsible for the debts incurred. That means, why is he ultimately responsible? Because he was a person who was managing the company, right? So he would be taking all the decisions on the company. So what unsecured creditors said was, since he was the beneficiary, that is he was receiving some form of benefit through the company and also he was responsible for all the actions of the company, he should be held liable for the liquidation for all the debts incurred in the company. So this was the allegation made by the unsecured creditors. What were the allegations? First one, so the remaining assets of 6,050 should be utilized for satisfaction of unsecured debt. On what grounds? The grounds were, Salomon was only a mere agent of the company. He is not different from the company which he has formed. Third, Salomon was the beneficiary and his family members were the beneficiary, and also Salomon was responsible for the bad decisions taken of the company and therefore the liabilities. So let's see what happened in the judgment. So once a case was filed, the court held that on incorporation, company gets a separate existence. That means it is different from the members forming the company and also it is different from the directors or the board of directors managing the company. So as I said, it is different from the subscribers to the memorandum. So who are subscribers to the memorandum? So every company on before incorporation, it has to prepare 2 important documents. One is Memorandum of Association and Articles of Association. So Memorandum of Association is basically the charter of the company which sets out the fundamental details of company, like the name of the company, where is the company located, what is the objects of the company, what is the liability of the members, what is the capital of the members, and also who are the subscribers, that is who are the initial contributories to the company. So the court held that the subscribers to the memorandum are different from the company formed. Second, after incorporation, though the business is precisely the same as before. So initially he had sole proprietorship, which was in the same form of a business, that is leather and boot manufacturing, right? After the company was incorporated, even the same business was same, right? So even he had incorporated a company for manufacturing boot and leather. So now the court held that before incorporation also, if the business is same, and after incorporation also business is the same, you cannot treat the company to be similar to the members, or should be similar to the directors, and the same persons are managers. So who are same persons as managers? We are talking about the members and the directors. As I said, one person can become a member, he can also become a director, and also become a creditor. So this was also the principle stated in this case. Next, the same hands receive profits. So how was the profit of a company shared between the members? It is shared in the form of dividends. So dividends are declared at the discretion of the board of directors. So board of directors would decide whether the company, if it is earning profits, whether it should utilize its profits for expansion and growth or for future, or it can declare dividend and share the profits of the members. So it is at the discretion of directors. Next, the company is not in law, the agent or trustee. So here the court held that irrespective of one person becoming a member, becoming a director, and in spite of he holding substantial interest in the company and also the business being precisely the same as before, member will be different from the company. So remember, you cannot club the identity of a natural person and identity of an artificial person. So here Salomon was a natural person, so the court held that natural identity and artificial person's identity can never be clubbed. So what is the artificial person? As I said, company enjoys similar benefits or entitlements just like a natural person. That means it has its own name, it has its own property, it can enter into contracts, it can open a bank account, it can employ people in its own name, right? So all these are the benefits which a company will be enjoying on incorporation. But it will not get citizenship. As per Constitution of India, citizenship is given only to a natural person, right? So now the court held that in case of a separate legal entity principle, a company's identity cannot be merged with the member's identity in spite of he holding substantial interest in the company. So this is all about the case. So remember, separate legal entity means the members of a company are not liable for the actions of the company, and the company is not liable for the actions of the members. So these are two different entities. You can never club the identities of a natural person and the artificial person. So this was all about the case. In the next video, you will be learning what are the exceptions to this principles of separate legal entity. That means when can you merge the identity of members and identity of company. That means when can members be held personally liable for any actions of the company. So that is called as doctrine of lifting of corporate veil. That means when can you merge the identity of a company and the members. So let's discuss that in the next video. So now we'll conclude this topic. Thank you. Now coming to dissolution of firm. What is dissolution of firm? It is nothing but the business is also coming to an end, and also the relationship between partners and the firm will also come to an end. For dissolution, there are two modes. One is with the intervention of court. That means a partner can file a suit in the court for dissolving the firm, or without the intervention of court. So let's understand what are the modes where a firm will be dissolved with the intervention of court. So the first one is unsound mind. Who is a person of unsound mind? A person is said to be a person of unsound mind when he cannot make rational decisions on a contract, or he is unable to understand the terms and conditions of a contract. Now, partnership, the basis of partnership is an agreement, right? Can a unsound person enter into an agreement? No. If he enters, that will be void, that is unenforceable. Now, when a partner becomes unsound mind, he will not be capable of entering into contracts and he will not be capable of being held liable for the actions of the firm. In such cases where one part, let's say there are five partners and one person becomes unsound mind or he becomes insane. So here the remaining four partners are still continuing the business and one partner says, let's dissolve the firm and not continue the firm. And the remaining partners are not agreeing to this. So what is the remedy? Well, one partner will have, he can file a suit in the court saying, I am against continuing this business because this partner has become unsound. I do not want to share the profits with this unsound person. So on these grounds, court can intervene and depending on the situation, it will be ordering appropriate judgment. So this is one ground, that is when one person becomes unsound mind, the other partner who does not want to continue the business of the firm can put an end to the firm by making a suit in the court. Second is permanent incapacity. Permanent incapacity means a person is incapable of continuing the work just like before the way he was continuing. Similarly, on the grounds of unsound mind, the person who is any other partner who feels to put an end to the firm's business because one partner has become permanently incapable and he does not want to continue to share the profits with the person who has become permanently incapable. In such cases, he can file a suit in the court and dissolve the firm. Next will be misconduct. So you all know when you were learning about duties of the partners, they are expected to act in good faith in the interest of the partnership firm and not to make any secret profits and to take all decisions diligently, right? If any one partner is not acting in good faith or does not conduct business diligently or due to his misconduct the firm is suffering continuous losses and the liability of the firm as a whole is increasing, then any one partner or all the remaining partners can file a suit in the court for dissolving the firm. Next is persistent breach of agreement. What is breach of agreement? It is nothing but not fulfilling the terms and conditions stated in the agreement, whether it is oral or in writing. If any one partner or most of the partners are not following the terms and conditions, the remaining partners who are affected by this persistent breach of agreement can file a suit in the court for dissolving the firm. Next will be continuous losses. So let's say a partnership firm is in existence for last 5 years and in all these 5 years it is suffering continuous losses and they do not want to continue the firm. But there are remaining partners who still have faith in their business idea that they are saying the business will still continue, let's not lose hope. But the remaining partners, few partners do not want to continue. So when there is any difference of opinion between partners on closing the business, they can file a suit in the court and the court will decide whether the firm should be put to an end or not. Next will be transfer of interest to third party. Again, coming back to the duty of a partner, you all know every partner has a duty of not transferring the interest to a third party. That means he cannot make a partner in his place. So just like in company, when you're transferring share from one person to the other, the transferee will become the member of the company, right? So in partnership, there is no such option of transferring of share of partnership. In case a partner transfers a share without the consent of the remaining partners, then the remaining partners can file a suit in the court for dissolving the firm. So basically understand, when will a partner file a suit in the court for these grounds? Only when there is deadlock situation or when the partners are not coming into equitable terms, they are not capable of arriving at any decision, then only to resolve the dispute, they will file a suit in the court. Apart from these grounds, any other equitable grounds where the court feels yes, this is a reasonable ground for admitting a suit, then such grounds will also be agreed. So these are the grounds where a firm can be put to an end by an order of the court. So next, moving on to dissolution of a firm, that is the business coming to an end without the intervention of court. So for this, there are other subclassification. First is voluntary, second is compulsory, third is on happening of contingencies, last one is dissolution of firm by notice. So let's see what are the grounds for voluntary dissolution of firm. So first is with consent of all the partners. Just like when you started the partnership firm with your own will to earn profits, When you want to put an end to the firm's business, that is by voluntary, all the partners are deciding to put an end to a firm, that is called as voluntary dissolution of firm. This applies to both partnership at will and particular partnership. Next is compulsory dissolution. That means when will a firm's business has to be compulsorily put to an end. First ground is all partners become insolvent. You know, an insolvent is incapable of entering into contract, right? When all the partners become insolvent, that means they don't have any personal assets to pay back the debts of an outsider, then they cannot continue the partnership firm, because you all know the liability of partners is unlimited. That means if the partnership firm's assets are not sufficient to pay back the debts of the outsiders, they have to use their personal assets. When all the partners have become insolvent, then obviously they cannot continue as partners. Second, all except one partner becomes insolvent. Let's say there are 5 partners, 4 partners become insolvent and only one partner is solvent. Can he still continue as a partner and the business be continued? No, because you know partnership is an association of persons. When we say association of persons, there should be at least 2 persons. Without 2 persons, partnership cannot be continuing. Now, when all the partners except one partner has become insolvent, one person who is capable of entering into a contract cannot continue the business. So, they have to close the business and then have to start a new business, or the nature of the business being the same, they have to start in the new name. Next, business becomes unlawful. So, let's say a partnership firm was carrying on the manufacturing of a particular chemical, and due to a new change in rule in the government, the chemical, there is a ban on production of the chemical. On such cases, on passing of a new law which makes a business becomes unlawful, then on such cases, the partnership will have to be compulsorily dissolved. That means the partnership firm will come to an end. Next, on happening of contingencies. So, what are the grounds for contingencies where a firm's business will be put to an end? So, in case of a death of a partner, this applies only if there is a contract, because you know there is reconstitution of a firm and dissolution of firm. If there is a contract between partners saying if either one of the partner dies, then we will not continue the business, then we call it as dissolution of firm due to death of a partner. Second is for a fixed period. You know the kinds of partnership, right? One is on the basis of time, on the other is on the basis of business. So, where on the basis of time you have fixed partnership and partnership at will. When the tenure of the partnership is fixed, on expiry of the term, the business will automatically come to an end. Let's say the partnership firm's tenure was 5 years, and on expiry of 5 years, the business will have to automatically come to an end, because it is a fixed partnership which is fixed for a particular period. Similarly, a partnership for fixed venture. So, on attainment or on reaching of that fixed venture, the business will automatically come to an end. Next will be insolvent parties only if it is stated in agreement. Just like death of a partner will not usually put an end to the business of the firm, but if there is an express contract between partners saying if either one of the partner becomes insolvent, then we will not continue the business of the firm, then the business will be dissolved or the firm will be dissolved. So, these are the grounds where a business will be coming to an end on happening of a contingency. So, next moving on to dissolution of firm by giving notice. So, by giving notice means any time any partner who wants to dissolve a partnership firm will be giving notice to the existing partners. So, this notice to be given to all the existing partners, and the date of dissolution will be either the date specified in the notice, or in case the date of dissolution is not specified, then the date of issue of notice will be deemed to the date of dissolution. So, these were the grounds for dissolution of a firm. So, what did you learn in this? You learnt about dissolution of partnership and dissolution of firm. What is the difference between dissolution of partnership and firm? Dissolution of partnership means the relationship between one partner and another partner along with the firm will come to an end and the business will not be affected. Whereas dissolution of firm means the relationship between partners will also come to an end and the business will also come to an end. So, the grounds for this reconstitution of firm is nothing but when a new partner is admitted or an existing partner is retired or death of a partner or expulsion or insolvency or change in sharing of profit ratio between partners. So, in these grounds the business will not come to an end, but only there will be change in the partnership agreement. Coming to dissolution of firm, where the business will be coming to an end, that can be done either with the intervention of court or without the intervention of court. When will the court intervene? When a partner will be filing a suit in the court, when they cannot resolve the issues between partners, only then the court can intervene. So these were the provisions on dissolution of firm. Let's begin with how company is different from partnership. So what is partnership? Partnership is nothing but one form of organization where two or more people come together, pool in their resources for what? For employing it in some trade or business, right? Out of that business, their intention is to earn profit, and the prima facie evidence for a partnership to be in existence is sharing of profits, right? That means when two people come together, those two people are called as partners who contribute to the capital and take part in the management. And the main intention of partnership is to share profits, right? For managing the business of partnership, either any one person can be acting on behalf of all the partners, or all the partners can take part in the management, right? So this is what you've learnt in partnership. So this is the basic understanding of partnership. Now, what is a company? Company is also a form of organization where two or more people come together, pool in their resources, and that common stock is called as share capital, right? You've already studied this in the definition. Now, one of the distinguishing feature for a company is there is separation in management and ownership, whereas in partnership, the partners will be the owners as well as the partners will be taking part in the management. But in case of a company, not necessary the members should become directors, or there is also no hard and fast rule that they cannot become directors, which means for managing a company, there are certain people elected by the members or the owners of the company, and those members are called as board of directors, and only board of directors are allowed to take part in the management. So this is one of the difference between company and partnership. So let's study in detail what are the other differences between a company and partnership. Now, for understanding this, we have classified into basis of difference. So on the basis of difference, we'll understand how is a company different from partnership. So the first basis of difference is separate legal entity. So this, as I was explaining in the feature of company, this is one of the unique and distinguishing feature of a company as compared to other forms of organization. So what was separate legal entity? Separate legal entity is nothing but once a company is registered or incorporated as per Companies Act 2013 or other any previous company laws, it gets a unique identity. It is different from the members forming it and also the persons who are managing the company. So one incorporation company enjoys all those benefits just like a natural person. That means it has its own name, it has its own existence, it has its own property. That means it can own property in its name, it can hold property, it can also dispose of property in its own name, and can also enter into contracts, and since it has contractual capacity, it can sue and be sued. And also remember, the members of the directors are not personally liable for any actions of the firm, and the company is not liable for the actions of the members or directors. So this is the meaning of separate legal entity. So on the basis of separate legal entity, we'll understand whether company and partnership is different. So as you all know, company has separate legal existence. That's why we've put a tick mark. And coming to partnership, there is no separate legal entity, which means the partners are not different from the firm and the firm is not different from the partners. So there is no separation of membership or partnership in case of a partnership form of organization. Next, moving on to separate property. As I was saying, on incorporation, company gets a unique identity. It gets all those rights just like a natural person except citizenship. Here, the company has all the rights to own property in its name. It can hold property as long as the company is in existence, and also it can dispose of at the time of liquidation when it wants to. And all this will be happening in the name of the company and not in the name of the member or in the name of a director. And here, one of the important point to note is the members, in spite of having substantial interest in the company, cannot exercise interest on the property of the company because company has its separate property. Whereas coming to partnership, there is no distinction because first of all, partnership is not treated as a separate legal entity. It is not treated different from its partners. Therefore, the partnership property is to be considered as property of the partners. Next, moving on to the other differences, relationship. So in relationship, what are we exactly talking about? So we are talking about agency relationship. So again, this point has a close connection to separate legal entity, right? Which means when I was saying on separate legal entity, I told you the members are not the agents of the company and the company is not the agent of the members. That means members or the owners are not personally liable to any of the actions of the company and the company is not liable for any actions of the members. In case of contractual capacity, company has the power to sue others and be sued in its own name. So in case of any fraud, the outsiders cannot file a suit in the name of a member but only in the name of a company. Similarly, company has all the rights to file a case against a third party and no member on behalf of the company will have any right. So this is the understanding of agency relationship. So in case of a company, the members are not treated to be agents nor the company is treated as agent of the members. Whereas in case of partnership, in the very definition it is clearly stated, either any one partner can take part in the management of the business or all the partners can take part in the management, which means when any one partner is acting on behalf of the entire firm, he is acting as an agent and the firm is the principal and also the other partners are principal. So in case of a partnership, partner is an agent of the firm and firm becomes the agent of the partners. So moving on to the next one, audit. Now here there are different types of audit, but here we are talking about financial audit. So as I was saying, there are different types of audit. There is management audit, there is labor audit, there is secretarial audit, there is financial audit. Here we are talking only about financial audit. So let's understand what exactly is a financial audit. So for running any form of organization, be it sole proprietorship, partnership, company, LLP, anything, finance is an important resource, right? So when finance is an important resource for running any form of organization, it's very important to record the receipts and payments, right? So who does this recording of receipts and payments? The financial department, a personnel would be appointed to transact or to record all those receipts and payments, right? So his duty is to only record how many receipts of the company and what were the payments made by the company. In this course of transaction, there should be some person to check whether all those transactions recorded are correct or not, right? Because you know in a company, the ownership is separate from the management. That means the shareholders would have put in their money to the company. They have all the right to know what has happened to the money which they have invested, right? So therefore, it is important for another person to cross-check whether the financial statements are depicting true and fair view. To give this understanding, a financial auditor, that is a chartered accountant, will be conducting audit. So basically, audit is nothing but checking the financial transactions as recorded by the company. So this process is called as financial audit. Now, as per Companies Act 2013, every company for an audit is compulsory. So it could be twice in a year or once in a year. If it is conducted twice in a year, it is called as interim audit. If it is conducted once in a year, it is called as final audit. So since the management is supposed to respond or are accountable for the shareholders' money, every single year a chartered accountant who is independent to the company has to conduct a financial audit and the report should be submitted to the shareholders. So moving on to partnership. So partnership, remember, it's on the basis of mutual trust and confidence. Now here, let's say you and your friends who know each other from last 10 years are starting up a business and the entire partnership firm is running on the mutual confidence, right? Now, if your friend is taking part in the financial transactions or he is recording all the financial transaction, there is some amount of trust and confidence you have on him, right? That means whatever transaction he is recording is correct. So you would not go for an audit, which means the Indian Partnership Act 1932 does not specify audit to be compulsory. It is only the discretion of partners whether the audit is to be done or not. So if the partners decide they want to have a financial audit, they can have, otherwise it's not a compulsion. But whereas in case of a company, whether the members want it or not, whether the directors want it or not, Companies Act 2013 has clearly specified that every year a financial audit should be conducted by a chartered accountant. So next, moving on to the other differences. Next is transferability of shares. So transferability of shares, again we've already discussed in the features of company, right? So which means in case of a private limited, the shares are transferable but with few restrictions which are stated in the Articles of Association. And in case of a public limited company, they are freely transferable. And in case of listed companies, they are traded on stock exchange, right? So we've already learnt about transferability of shares. But what in case of partnership? Can the share a partner is holding in a firm be transferred just like a share in a company? No, it cannot be, because as I said, partnership is purely based on mutual trust and confidence. So if any partner wants to transfer a share, that is not allowed in partnership, which means if a partner does not want to continue in the firm, he can either retire from the firm and then the remaining partner would decide to appoint a new partner or not. But when a partner is in the partnership firm, he cannot transfer his share to another person and he can make another partner as a partner in the firm in his place. So remember, there is no transferability of shares in partnership. Next, moving on to liability. So liability basically means the obligation to pay back the debts. In case of a company, one of the important feature which you learnt was limited liability, right? Which means the liability of members or the owners or the people who have contributed to the company is limited up to the shares they have subscribed to or agreed to subscribe, right? And only their liability arises when the shares are partly paid up. So only the unpaid value can be called by the company and not more than that, right? Which means the liability of a company is limited, and in case of a partnership, it is unlimited, which means in case the partners are unable to pay back the debts of the outsiders, that means the partnership assets are not enough, then they'll have to use their personal assets, and then out of the proceeds of the personal assets, they have to pay back the debts of the outsiders, which means the partner's liability is unlimited and the member's liability in case of a company is limited. So moving on to the next basis of difference. So next difference is the members or partners. So what are the minimum number of requirements for a persons to start a company? So as I said, in a company there are different forms. First one is OPC. OPC is nothing but one person company. Basically OPC is a combination of a sole proprietorship and a company there, which means there is only one sole member who takes part in the company form of organization. That means there is only one sole member, but the management could be, again it is different. That means minimum one director should be appointed and maximum 15 directors can be appointed. Next, coming to private company. Private company is a form of organization where there are certain restrictions on transferability of shares, there are limitations on the number of members in a company, and there are restrictions on to, there is prohibition on issuing prospectus to public. That means they cannot raise capital by issuing prospectus. Coming to public company is a company which is not a private company, which means there is no restriction on the number of members, there is no limitation or restrictions on the transferability of shares, and also there is no prohibition for issue of shares to public. So in case of a one-person company, minimum one person should be there to start an organization, and since the name suggests it's a one-person company, the maximum also remains 1. So which means one-person company minimum and maximum is 1. It cannot be more than 1. Coming to private limited, as I was saying, since a company is an association of persons, for any association of persons there should be at least minimum 2 members and the maximum can extend to 200. Okay, and moving on to the next kind of category, that is public company. So to start a public limited company, at least 7 members should be coming together, should pool in their resources and should be subscribing to the memorandum of the association. And number of members maximum limit is unlimited, because as I said, public company is any company which is not a private company, which means it does not limit on the number of members it has. So the maximum number of members in case of a public limited is unlimited. Next, moving on to partnership. So partnership is an association of persons, therefore at least 2 members are required to start a partnership, and it can extend to as much as 50 people. So earlier in the previous act, that is Partnership Act 1932, the maximum limit on number of partners was 10 and 20 in case of banking and general business respectively. But now later in an amendment in Companies Act 2015, the maximum limit of any association of persons apart from a company will be 50. So therefore, the partnership, in case of a partnership form of organization, the number of partners cannot exceed 50. So these were the differences between a company and partnership. For an agreement to become a contract, it's just not enough. There should be a subject matter and parties, but also all those essential elements to make a agreement valid, that is to be enforced in the court of law. There are certain elements stated in section 10 of Indian Contract Act. So you have to add those elements to the agreement, and only then it can be enforced in the court of law. A mere agreement cannot be enforced until unless all these essential elements which you are going to study will be involved or it will be placed in the agreement. So let's see what is section 10, and coming from an exam perspective and your basic knowledge, section 10 plays a very important role. Why? Because it's just not business entities who enter into contract, but all of us do enter into contracts, right? So to check whether you're entitled to receive a remedy in the court of law or not, the agreement between you and the other party should be valid. When will it be valid? If it is a contract and all the section 10 elements are added to the agreement. So let's see what exactly is the section 10. So first, essentials of a valid contract, that is which is stated in section 10. So the first essential is valid offer. So what do you mean by offer? As I said, if you are buying a car, you go to the showroom, you ask the seller, will you sell this car? So this is called as an offer, and the person who's making the offer is called as offerer. So a mere offer will not be valid. When will it be valid? There are certain rules and regulations which is prescribed in Indian Contract Act to make an offer valid. Until unless these conditions are complied with, it will not make an valid offer. And if it is not a valid offer, it cannot make a contract. So likewise, we have valid acceptance. When one person is making an offer, the other person should also accept, right? Until unless acceptance is done, contract cannot happen. Again, for an acceptance, there are certain rules and regulations which the party should be complying with. So until unless acceptance is valid, it cannot become a contract. So next essential, intention of creating legal obligations. So in an agreement, there are different types of agreement. One is domestic agreement, social agreement, and commercial agreement. So which of these agreements are enforceable in contract in the court of law? Only those agreements which has an intention of creating legal obligation, that is only commercial contracts, commercial agreements can be enforced in the court of law. So in the next video, you'll be understanding this in detail. So as of now, just remember these are the essentials of the valid contract. Next, moving on to lawful consideration. So as I said, consideration in Contract Act is nothing but something in return. So if A is selling the car to B, what is he receiving? He's receiving 10 lakh rupees. And if B is paying 10 lakh rupees, what is he receiving? He's receiving the car. So in a contract, both the parties for performing their obligation should be receiving something in return. If there is no consideration, it will not be a valid contract, and again it cannot be enforced in the court of law. And the term is lawful consideration, which means the consideration that is something in return for the party should be lawful, that is it should not be forbidden by law. Next, moving on to lawful object. Object here basically means the subject matter. So what was the subject matter of our agreement? Sale of car. Is it an object which is forbidden by law? No, right? Every one of us do purchase car and there are so many sellers who will be selling car. It's a valid object. But what are unlawful object? So those agreements which has an object of committing a crime, maybe to kidnap someone or to commit murder or to deal in drugs, all these are called as unlawful object. So to be a valid contract, the subject matter should be lawful, that is which is not forbidden by the law. Next, capacity to contract. So here capacity to contract is understood in terms of the parties. So parties, that is both the seller and the buyer, should be capable of entering into contract, which means there are certain essential requirements under capacity to contract, which says a person to enter into a contract, that is both the parties should have attained the age of majority. Second, they should be of sound mind, which means at the time of entering contract, they should be capable of making a rational decision whether their contract is in their favor or not, or they're receiving any benefit or not. And they should not be unsound mind, which means they should not be under the influence of drugs or alcohol, wherein they lose their mental capacity to enter into contract. And also there are people disqualified by law who are alien enemies, insolvent, convicts, foreign ambassadors and corporations. So these are people who cannot enter into contract. So again, you'll be studying all these technicalities in the later stage. So what do you mean by capacity to contract? The parties entering into the contract should be capable of entering into contract. Next, moving on to free consent. So here consent means approval, right? So when parties are entering into a contract, they should enter into a contract with their own will, that is voluntary involvement in the contract. So neither of the parties should be forced to perform any obligation. So in our example, A, that is the seller, should not be forced to sell his car, and buyer should not be forced to buy the car. So free consent is basically vitiated by 5 conditions. One is coercion, undue influence, mistake, misrepresentation and fraud. So when these 5 elements are existing in an agreement, it cannot make a contract. So next, moving on to certainty of meaning. So when you're buying a car, it's very important to understand the terms and conditions, right? Because that's why I told you how a agreement is structured. So first parties meet, they finalize the terms and conditions. So here certainty of meaning, we're talking about the terms and conditions. So let's say I have 3 cars and I make an offer, I will sell my car to you. So have I specified which car, which brand, what mileage it gives and what price? No, right? So when the terms are vague or indefinite, it cannot make a valid contract. So both the parties should enter with free consent. They should be capable of entering into contracts, and the terms and conditions should be clearly specified. Next, agreement not declared as void or illegal. So there are already few agreements which are stated in Indian Contract Act which are void. What do you mean by void? Void is nothing but something which is unenforceable. So the Contract Act already has specified there are certain agreements which cannot be enforced in the court of law. For example, agreement and restraint of trade, agreement and restraint of marriage, or agreement and restraint of legal proceedings. All these are agreements which are expressly void. So even if you enter into such agreements, it cannot be enforced in the court of law. And also those agreements which are illegal. Basically, the object of the agreement, if it is illegal or something which is forbidden by law, will not be allowed to be enforced in the court of law. Next, possibility of performance. So when you're entering into a contract, what is the intention? Both the parties will be promising to perform certain obligations, right? Those obligations should be capable of being performed. Let's say, for example, A and B enter into an agreement where A is supposed to discover treasure by magic. So is it possible? No, right? And such agreements which is not capable of performance will not become a valid contract. So the last essential is necessary legal formalities. So here understand, a contract could be either an express or an implied, which means express means those terms and conditions which are expressly stated either in writing or in oral, which means you might be thinking, how can a contract be in oral terms? It can be in oral terms, but how do you prove in the court of law? It's up to the parties. But the Contract Act never specifies it should be in writing. So the option is given to the parties, either it could be in oral or it could be in writing. What is implied contract? The terms and conditions are implied by the conduct of the parties. So what does this necessary legal formalities mean? So there are certain contracts according to different acts which needs to be in writing, which needs to be registered and which needs to be stamped. So according to those provisions, certain contracts need to comply with certain legal formalities. Only then it can be enforced in the court of law. So these were the essentials element to make an agreement enforceable in law. So coming back to the definition of contract, what is a contract? An agreement enforceable by law. So agreement is nothing but every promise and every set of promises forming consideration, right? To this agreement, we are adding all these 10 essential elements. So let's get back, let's do a quick revision. So to make a contract, there should be an agreement. Next, there should be enforceability, that is section 10. All the elements should be stated in the agreement. and that becomes a contract, which means if any of the parties fail to perform their obligations, the aggrieved party can sue the party who has not performed the obligations in the court of law, and the court of law will provide appropriate remedy.
Hello all. Today we will be discussing about comprehension. Comprehension is the ability to understand something. So, at the end of this video or this particular module, you need to understand how to read a given text of varied length and subject. Also, you need to know the various strategies and skill to be a successful reader, and also to give the information critically or take the given information critically. So, the main goals of this particular module is to make you understand how to read a particular length of text of various subject, and also how to apply the strategies of good reading in your day-to-day life to become a successful reader, and also how to take the information critically, or with the available information how can you take whatever is very important. So now let's discuss something about the strategies of attempting a comprehension passage. We know that in a subject like English, or for that matter any language, comprehension passage is an important thing. They will be giving a passage and a few questions behind that, you need to answer it. So what are the strategies you need to know while attempting a comprehension passage? First thing, read the passage quickly to understand the main idea. What you have to do is, as soon as you get a passage, glance through it quickly, because once you take sufficient time to read, our brain will process something other than whatever is in the text. So don't give that chance. Read it quickly, and once you read it quickly, it is advisable to you that underline the main points. Make sure whatever comes into your mind, whatever you feel it is important, mark a point. As soon as you finish this, go to the last section, that is scan through all the questions available. Check how many questions are there, give a scan, or just read all the questions. For the maybe there will be 5 questions, 10 questions, read the questions. Why to read the question? Because once you read the question, then you need to reread the passage. Now you exactly know what are the informations that you need from the passage, or what are the things that are to be extracted from the given passage, because you know there are 10 questions and you need to find the answer for 10 questions. So reread the passage, making specific information related to the question. So first time when you read, it was to understand the passage and you pointed out the important points. Second time when you read after scanning the question, now you exactly know what are the things to be taken from it. So reread the passage, making specific information related to the question. Now, there are chances, and many a times you will find similar answers. Much of the time this happens with the MCQs, or multiple choice question. When you are attempting a multiple choice question, what happens is, out of given 4 options say, you will find all the 4 options very similar. That will create a sense of ambiguity or confusions. But to avoid this, go through the passage once again. You will find a minute difference with the given options. So rereading will help you to get the best answer and find the smallest difference. Finally, review before you move to the next question. That is, once you have got the answer for it, read the passage once again. Make sure that this answer suits this question properly. You need to repeat this step for all the questions. So quickly, what are the strategies for comprehension passage or attempting a passage is, first, read the passage quickly, give a glance, then understand or underline what is important, go through the questions very quickly, reread the passage, start finding answer to each and every question. So this strategy if you follow, or this step if you follow while studying a comprehension passage, I am sure you will get answer to all the questions. So best exercise today is, go back, take any text or take any previous comprehension passage, apply this strategy, find the answers. I think you will get the answer within 5 minutes. That is how you should attempt a comprehension passage. Now, there is something called Bloom's taxonomy. Bloom's taxonomy is a pyramid. There are 6 steps in this pyramid. This pyramid is typically done to make a student understand the learning and thinking capability what he or she has. So you see this pyramid, you see 6 steps in that or 6 points. All these 6 points will be applied when you read a passage. So let's start with remembering. You read a passage, you will remember few important things, you can recall it. As and when the question arrives, you need to recall it. Next is understand. What is understanding? You read the entire passage, you understand something there. What is the importance, or maybe the theme, maybe the content, maybe the purpose. Then comes applying. You find some interesting words there. You try to apply it in your day-to-day life also. Then analyze or analysis capacity. What is analyze? You need to answer some questions with that. And finally, evaluate. What is the main theme of the comprehension? You evaluate it. And create. With the help of this, will you be able to create something similar of your own? That is Bloom's taxonomy. These points you need to remember while answering the questions. Let me tell how. See, the various types of questions what you see are, first one is asking specific details from the content or body of the passage. So this type of question, there will be question asking details. So what will help from the Bloom's taxonomy is whatever you remember or whatever you have understood. Once you have understood the concept, once you have understood the passage, once you remember something, you can answer this type of question. The second type of question, determining the meaning of words, phrases, idioms used in the passage. See, determining the meaning. How do you understand the meaning of word? Once you understand the passage, you will know why this particular word is used. Or once you have analyzed the passage, you will find the answer to this particular question. Drawing inferences and conclusions. Again, it is understanding capacity and evaluating. Once you evaluate the thing, you can draw inferences and conclusions. Identifying the tone of the author or the passage. See, what is the tone of the author? Is it a suggestion? Is it a complaint? Is it a request? Every author will have his or her own tone. So once you read the passage, you can identify the tone of the speaker. When you have evaluated the passage, you can understand the tone of the speaker. Main idea or theme of the passage. When will you understand this? When you have understood it completely, analyzed it completely and evaluated it, you will know the main idea or theme of the passage. Suitable title of the passage is the topmost section of your pyramid, that is create. You have done all these things. Now it is your turn to create a suitable title for the passage. How will you create a title? You have understood, you have read, you have recollected, you have evaluated, you have analyzed. So finally, you will create a title for the passage. So these are the types of question every passage will follow. So this is how Bloom's taxonomy and the questions will be interrelated. So the main purpose of Bloom's taxonomy is to make student understand entire concept of the passage and make sure he or she gets the point from the complete passage. So with this, reading is generally a complex activity or a process that draws upon many skills. So to be a good reader, what you can do is read something which gives you more interest. Read in the time of the day which your mind is fresh. For example, many a times to read you need to have an open mind, preferably in the first part of the day, because it is a time when your mind is free, you are fresh enough to gather the information. Read with your mind open. Make sure that you have a purpose of reading to collect some information. So keep your mind open, take as much as information from the available thing, because the ultimate goal of reading is to make meaning from the point or meaning from the print. So what is your ultimate goal? As we said at the end of this module, you should understand whatever is given in front of you in the model of a print. So by reading every time any text, any book, any paper, any piece of paper or a message, if you follow the strategies of reading or if you apply the Bloom's taxonomy, you need to finally understand the meaning from the print or given method. So with this, reading is an easy process. From complex, now we have done it to easy. So we'll conclude this. I hope you will all start reading the same way as followed with the help of strategies and try applying Bloom's taxonomy pyramid. Thank you all. So generally, a shortening of text in one's own words is known as precise writing. The term is again derived from French, and thus generally we can call precise gives an accurate and concise description of a substance contained in the text. Main thing is without losing its meaning. So whenever you shorten something, make sure the meaning is same or meaning doesn't go away. So when we discuss this, I think many of you might have all thought, why is she saying precise? It can be called as summary as well, isn't it? But I'll tell you very clearly, precise is different, summary is different. Basically, there are three important differences for precise and summary. We'll begin with the first one. First difference, precise is shortening of a text of something smaller in nature. Best examples are a small report of your speech, a lesson, or a single poem. Whereas summary is shortening of an entire syllabus or maybe an entire novel or maybe a movie, whichever you have watched. So the first basic difference is precise is shortening of something small in nature, whereas summary is shortening something which is larger in nature. Now coming to the second important difference. The second difference is, in a precise, you need to follow the orders which are same in the text. See, we'll just take an example of a speech. Generally, a speech will start with a welcoming note, will further go with the introduction and then the body of the speech, and finally we'll conclude it. So when you do a precise of a speech, you need to write it like Mr. XYZ welcomed the chief guest, he introduced the chief guest, and then he spoke about the main content of today's program, and finally he concluded with the Thanksgiving note. But whereas in a summary, what you can do is you can add your own points or you can change the sequence as well. So that is the second difference. The third and important decision is, in a precise, it should not be your opinion or a writer's opinion. Whereas in summary, once you write a summary, you can write the things which you have understood because of that text or because of that particular material. So precise, small thing, accurate meaning, no changes. Whereas summary, a larger note with your own understanding capabilities and your valuable thoughts can be included. So I hope everyone are clear with difference of precise and summary. So leave ahead of summary because this module completely deals with precise. So let's focus now on precise. So qualities of a good precise. Whenever you precise something, what are the qualities that are to be followed, or how should be a good precise be? Let's start one by one. The first one is clarity. That means give a clear picture of whatever you want to tell. Generally we have no time now. It's a time or it's a situation where everyone are in hurry. Nobody will like to read the complete text, or nobody will write to have time spent on all the things. So whenever you write a precise, make sure you're clear with the point. Stick up to the point, directly bang on to the point. That is the first quality. You should be very clear on what you are explaining or what is your main topic. The second thing is objectivity. That is, stick on to the objective of the precise. You need not focus anything else apart from the main content. It is that whatever is in the main content, only so much can be included in the precise. Now, third important thing is correctness. What is correctness? You may feel whenever we do a summary, it is as it is we are producing it down. But correctness is something that when you write something, make sure the facts are correct. Anyhow, almost all the facts will be correct. We just read something or seen something and writing it. But apart from the correctness of fact, important thing is the grammatical correctness or the proper use of word and with the proper spelling. See, there are many words or many sentences which will give you a misunderstanding. So whenever you write a precise, make sure you use the words which will fit exactly into the sentence and which will give the exact meaning. Do not try to use jargons or any technical words which will end up in misunderstanding. Now, coherence. What is this coherence? Coherence is nothing but you need to follow the order. Whatever the order is in your main text, you need to follow the same. Or whatever the theme is in the main text, you need to follow the same. You don't have a chance to input your points or alter any given points. So, coherence means follow exactly what is in the main text. The next is completeness. See, many a time what habit we have? We have a huge paragraph. For example, say one of your teachers said, precise a complete lesson. What you do? Just avoid some sentences, write some sentences, give it back to her. Is it a precise? No. Precise should be complete. It should include all the points of the lesson but with the fewer and lesser words. Here your hold on the language will be checked. That is why precise writing is important not only as a student. Whenever you go higher up in a career, it is very important how do you precise an entire meeting. Your boss will be asking you, give the minutes of meeting. What is minutes of meeting? It is just the precise. You need to include each and every point done in the meeting without missing a single thing but with limited number of words. For that you can write, rewrite, redo, change the words, change the sentence, but make sure each and everything is included. So the last point is concise. Once again, as we said, people don't have much time to read everything and the main purpose of precise is to shorten. So it should be in a limited number of sentences. For example, if your complete lesson is 2.5 pages, your precise should be not more than half page. That is how the measurement you can take whenever you do. Or in an exam, if they have given you a paragraph, do one thing, count the lines. Maybe it will be 30, 40 lines. Make sure your precise doesn't exceed 7 to 8 lines. So qualities of a good precise are, be clear what you want to tell. Objective means have the ideas taken from the text, not your opinion. Use correct words, correct sentences and exact facts. Then comes coherence. Follow the same order as and how it is in the main text. Completeness is important because give the complete data. Even if it is small, give the complete data. And concise, small things are very beautiful. That itself is concise. Reproduce something in a smaller way. So these are the qualities of a good precise. So whenever you want to do a precise of your entire lesson, because you all will study every day, so you can do it in a shorter form. So best exercise would be, do one thing, after the completion of this video, sit and write a precise of this. So you will get an idea what exactly is it. Go back to it or take your book, see what are the points you have covered. So now, precise writing also has a procedure. See, English is a language or communication is like that. Each and everything we need to follow a procedure. That is how the language is. That is the beauty of this language. You can't add up something extra, you can't remove something. For each and everything, there is a perfect procedure or step-by-step procedure which you can follow everywhere. So first thing, read the passage carefully more than once required. So whenever you are given a document, read it. Read it aram se, take your time. Once again you read it and make sure all the points are covered or you keep in mind whatever things are there. Then decide what facts or idea in the text are essential and what are of secondary or no importance. So once you read it, you will understand what it is. Second time once you read it, you will understand what are the important things, what are not important. So what you can do is keep a pen and a pencil. Whatever is important, underline with a pen. Whichever is not important, mark and into mark with a pencil. Easy to differentiate. But if it is in an exam, you cannot do all those stuff, right? Many a times writing on the question paper is a problem. All those stuff will be there. What you can do better is, in your paper, make quick notes. Important points, 1, 2, 3. For example, the precise will be of India's independence struggle. So important points general will be the dates. First war of Indian independence, or maybe the East India Company, Dundee March, Salt Satyagraha, Mahatma Gandhi ji, Bhagat Singh, Jawaharlal Nehru, whatever comes into mind, make. And whichever is not so important. You may feel some things are okay, this is repeatedly told or this is not in relation to this particular topic. So leave that. Now, third important step is select a suitable title for your proposed precis. Whenever you do a precis, make sure it has a title, because title will be the eye-catching thing. Whenever you write something, what is it? See, you cannot just write the same title as in the textbook. It is same, but you make sure. Now, for example, I gave you an example of India's independence struggle. So, you can make a title, India 1947 or India Freedom, something like that. So, prepare a suitable title for it. Then, collect all the key points and prepare the first draft. Now, you have written so many points. Now, we have studied in a quality of good precis that it should follow the order, that is coherence. So, what you have to do is collect all the points, arrange it in the order which you want. Maybe you can choose a chronological order from the beginning to the end, or you can take the reverse order also. But once you take an order, you should follow it. Next thing is, make sure your points noted down are complete, or it gives a complete picture of your precis. It should not omit or avoid any important point of the main document. Now, once you are done with it, read the draft. You take the book, you read whatever you have written. It may so happen that if it is too long, you need to shorten it. The last point of quality of a good precis, that is completeness or concise. Read it, read the draft, make sure everything is included, and then finally if you feel it is too lengthy, shorten it. Once again, to shorten, you need to do all the steps, read again, reread again, collect the important points, prepare the list and further shorten it. And when you have made your final draft, revise your precis. For revising, you can give a break. You do the draft, keep it, close it, take some time, take a deep breath, go outside, watch something, come back, and then you make the final draft. Why? Because when you have done continuously, ideas won't run in your mind. If you give a break, again you will understand the minute mistakes or maybe the grammatical error, or you may get a better idea to do it. So, these are the steps. How do you do a precis, or how should a precis be good? We can just conclude this by saying precis writing is a very important exercise, because see, we have 10 modules to study, 20 modules to study. Each module, for example, say 20 pages, 30 pages, 40 pages. We don't have time to read all the pages on the day of your exam. From point of view of exam, if you have precised your modules, it's a hand. Morning, wake up, see all the precis. Like every lesson will be one page, important points will be there, entire thing will be covered. So, it also give you a training for careful reading, and it will develop your capacity to discriminate between essentials and non-essentials. Because as we discussed in our previous thing, in precis, you will first make note what are important points. Now, in your lesson, how do you make this? You take 5 years question paper, you check all the repeated questions. Okay, then you finally feel some of the points are not important. So, you keep it aside, right? So, this precis writing exercise will make sure that what is important, what is not so essential, so that you can give a proper differentiation. So, I hope with this you know what is precis writing, and now I expect everyone to do a precis of this particular video, maybe in 4 sentences, but it should include all the points whatever has been included in this video. So, thank you all. See you with an exciting video tomorrow.